I welcome you all on the behalf of Nani Palkiwala National Law Club. Today we have our guest, Advocate Jayprakash Somani, Supreme Court of India, and our topic is compensatory ground for the service matters. The main essence of this compensatory ground is how quickly you apply the moment some mishappening has happened in the family and you can get the compensate. Some more case laws will be discussed with the sir. Over to you, sir.
Thank you. Thank you, Manoj. Today's subject is compassionate appointment in job. Supreme Court of India's top 15 landmark judgments. So friends, whenever is in government job or in public sector companies like that, banks, so whenever is dying, anybody is dying in harness while doing his duty, that time his dependent, any of the dependent can get the job. If anybody is not in government job or in a secured job, their financial position is not good. In that circumstances, to overcome from that harness hardship, this compassionate appointment in job, this facility is given all over India. So little bit I will explain you first some information about compassionate appointment, and then I will initiate 15 landmark judgment in short description, short judgment, short ratio descendi, and citation with citation. So friends, in India, compassionate appointments refer to the provision that allows the appointment of dependents of deceased or retired government employees on compassionate ground. This policy is primarily aimed at providing immediate financial relief to the family members of the deceased employees who may be left in distress due to the loss of their earning member. Key features of compassionate appointment in India. Eligibility. Compassionate appointments are usually provided to spouse, children, or dependents of the deceased or retired government employees. The specific family members eligible can vary depending upon the rules of the respective state or central government department. So bank have different rules, state government have different rules, central government have different rules, public undertaking companies have different rules. So rules are maybe different little bit, but eligibility is like this. So that particular person should be died in harness while doing his duty, or he should be retired. And after retirement, immediate job, if it is necessary, so that can be given under compassionate appointment round. Second, criteria for selection. The family must demonstrate that they are in need of financial support. The appointment is not based on a merit, but is intended to provide immediate relief. This appointment is not based upon the merit, but it is intended to provide immediate relief. The appointment may have to meet certain educational qualifications as stipulated by the respective government department. What are the government guidelines for this appointment? Various government departments have their own guidelines that govern the compassionate appointment process. The central government and state governments often have different sets of rules. The instructions regarding compassionate appointments are laid down in the respective service rules. What is the time frame? Typically, applications for compassionate appointment must be submitted within a designated period after the employee's death or retirement, often within 1 year. But this may differ according to specific rules. So these are the rules. So within 1 year, one should apply. And if that applicant is a minor, that time after becoming a major, even though distress is there, even though is a poverty is there to that family, they are striving. That time after getting major of that particular his legal hair, he will get the job when he become a major. And many times, many banks, many institutions are very honest to give the compassionate appoint. They are regularly sending the mails to the dependent, and they are getting all work done from them. But some are very stringent. So then department is not hearing properly. Then they have to file the writ petition in High Court. Then after High Court, single bench, double bench, divisional bench, LPA order. And after LPA order, appeal comes to in our court, Supreme Court. So that happens when the department in which compassionate appointment is likely to be given are very strict or very stringent. So friends, now we will go step by step to 15 judgments. First, UK Sengal versus State of Jammu and Kashmir, 2000 case. This case was decided in 2000. Short facts: the petitioner sought appointment on compassionate grounds after the death of his father, who was serving as a teacher. Decision: the court held that compassionate appointment should be made based on the guidelines established and that the applicant must be the dependent of the deceased employee. Ratio decidendi: the purpose of a compassionate appointment is to provide immediate relief to the family of deceased employee, recognizing the financial distress caused by the loss. Citation of this case: 2007 SCC 601. Case number 2. Sanjay Kumar versus State of Bihar. This case was decided in 2005. Facts, short facts. The applicant claimed a compassionate appointment after the death of his father, who was in government service. Decision: the Supreme Court stressed that mere eligibility does not guarantee a compassionate appointment and stated that the applicant's financial condition is crucial in evaluating the application. So only eligibility is not the criteria, but family's overall financial condition should be crucial. That time, this appointment can be given. This is the decision of court. What is the ratio decidendi in this case? The court emphasized that compassionate appointments are a privilege rather than a right. It is not a right, but it is a privilege. Citation: 2005 9 SCC 127. Friends, case number 3, Director of Education versus Pushpender Kumar. This case was decided in 2005. Facts: the case involved a dispute regarding the interpretation of the appointment rules after the death of employee. Decision: the Supreme Court ruled in favor of the applicant, indicating that the application was made within the stipulated time. Ratio decidendi: prompt disposal of application for compassionate appointment is crucial. Crucial means necessary. It should be a fast to ensure timely relief to the family. So this case was completely in favor of the applicant. That means petitioner. Citation: 2005 11 SCC 360. Then case number 4, friends. Union of India versus SA Karamchari Sangh. This case was decided in 2003. Fact: The petitioners challenge a circular from the railway regarding compassionate appointments. Decision: the Supreme Court upheld the circular's provision, clarifying that they were within the authority of the department. What is the ratio dissent in this? Administrative regulations may establish proper channel for compassionate appointments. Citation 2003-4 SCC 501. Friends, case number 5, Bhagwan Das versus State of Haryana. This case was decided in 2010. Facts: a claim for compassionate appointment was made after the death of the petitioner's father, who was a government employee. Decision: the Supreme Court held that economic hardship must be established to warrant a compassionate appointment. Economic hardship should be established, must be established. So that time compassionate appointment can be warranted. Ratio discendi, the objective is to relieve the financial plight of the deceased family. Citation of this case 2010 3 SCC 327. Case number 6, friends. KCS Ray versus State of West Bengal 2009. Facts: the case was about a government employee who died and the family sought representation for compassionate appointment. Decision: the Supreme Court took a firm stance on validating the application based on family circumstances. So Supreme Court gave the decision in favor of the employee. Ratio discendi, compassionate appointment policy should be interpreted with a human perspective. Citation of this case 2009-11 SCC 499. Friends, case number 7, Govind Prasad versus State of Uttar Pradesh 2006. Facts: after the death of employee in government service, a claim was made by the dependent for compassionate appointment. Compassionate means anukampa in Hindi. Decision: the Supreme Court ruled that the application must be considered as per the rule set out by the department. Ratio discendi, compassionate appointments are guided by a defined set of rules and should not be the arbitrary. So, citation of this case 2006-10 SCC 490. Then case number 8, State of Maharashtra versus Rakesh Kumar. This case was decided in 2019. Facts: the petition concerning eligibility and the time limitation for applying for compassionate appointment was posed. Decision: the court reiterate, means saying again and again, the court reiterate that compassionate appointments should consider the guidelines regarding the time limit and dependency. So department should consider any compassionate appointment application in a time frame and dependency of that particular family. They should not drag it month and month like that. So ratio discendi, applications are time bound and must be aligned with the emerged removal from the service of the deceased. Citation 2019 to SCC 695. I am very happy to share that so many matters are coming to Supreme Court related to the compassionate appointment, related to other service matter. Near about more than 10 books on service matters, Supreme Court case laws are published by me. All these books are available on Amazon, Flipkart. And if you just type Jayprakash Somani books, you will find more than 60 books of mine. Because of the Lord Sri Krishna's grace and due to the help of my juniors, interns, I am able to do such type of works in last few years. So there are so many, and that will be a detailed. So in detailed judgments, properly short synopsis like that there, decision. And many high court lawyer, many Supreme Court lawyer are using that books. So more than out of that 60 books, more than 10 books are on service matters. And we are handling all types of services matters in Supreme Court. And very, very clear and crystal clear injustice when we saw that justice not cured by the High Court, not single bench, not double bench. Sometimes single bench is giving the decision in favor, but double bench reverted it. And then petitioner is coming to Supreme Court. And sometimes single bench giving it their favor, then department goes to double bench. Double bench decision is also in favor. Then department is coming to Supreme Court. That time automatically respondent have to come to Supreme Court to respond. In such cases, caveat should be filed. When you are the winner in High Court, so caveat should be filed in Supreme Court. So then at the time of entry, you can completely oppose to that particular case, and you can dismiss that particular case at the time of entry if you have filed the caveat. So caveat filing is very important if you are winner of the High Court case. And immediately when you are winning the case in High Court, immediately file caveat also in Supreme Court, so that if a respondent is coming to Supreme Court, that time you will get the notice because of caveat, and at the time of entry we can fight that and we can oppose that case, and we will try to dismiss that case from Supreme Court. That means automatically High Court judgment is in your favor. Simultaneously, whether respondent is coming to Supreme Court or not, simultaneously you should file contempt petition against the High Court order after completing that specific period. Suppose High Court order is giving in their order, so kindly give the appointment to this petitioner within a 1 month. So just wait for 1 month, and after 1 month, before that, after getting the order, you give one representation to the department. So as per the order, I'm submitting my representation. Kindly give me the appointment. And even though after 1 month the department is not giving appointment, so immediately you file the contempt also, and you file caveat also in Supreme Court. So take this precaution. So, and tell your client, if lawyer is watching this video, so tell your client to take care. Don't be careless after winning the case in High Court. There are so many cases after getting High Court's order in their favor, but they have not filed any contempt petition. They are just waiting. High Court's order is in my favor, I will get the appointment. But they are not giving representation, they are not finding contempt petition, and after 5 years then they try to do that. So then High Court will tell you, this is a lapse of time, limitation is not there now. That time, even though you are winning case, and that time High Court oppose you, then you come to Supreme Court, then we will fight the case, and when sufficient cause is there, delay can be condoned. So such type of things are there. But whenever you are winning the case in High Court, so don't wait for justice, just immediate give the representation to department. As per this order, give me the job, give me the appointment, and in that specific period which mentioned in High Court order is not given the job by the respondent, that time you immediately file contempt petition in same High Court. And simultaneously, you should file a caveat in Supreme Court, because whenever he is intended to the come to Supreme Court, that means respondent come to Supreme Court, that time it is easy for you and for your lawyer to fight that matter at admission stage. Okay. So now we are moving to case number 9. Amar Singh versus Union of India. Facts: an application for appointment after the family member's death serving in the army was challenged. Decision: the Supreme Court laid down the condition under which such appointments can be granted. Ratio decidendi emphasizes the need for a direct financial dependency ratio and guidelines are there. Citation 2011 for SCC 70. Case number 10, friends. Suresh Kumar versus State of Haryana, 2017. Facts: the applicant sought a compassionate appointment after the untimely demise of a family member. Demise means death. Decision: the court favored individual circumstances where the deceased had a consistent and sustainable income. Ratio decidendi emphasized the need for a holistic view of a family's independence. So, citation of this case is 2017 1 SCC 105. Now, case number 11, MST Suman versus State of Madhya Pradesh, 2019. Facts: the application for compassionate appointment was contested by the state with regard to unattachment of families to the deceased employee's service. Decision: the Supreme Court ruled that families who suffered unfair hardship should be given priority. Family who suffer unfair hardship should be given priority. This was the decision of the Supreme Court in this case. Ratio decidendi, the court recognized emotional attachment alongside financial concern. And citation of this case is 2019 8 RCC Civil 745. Case number 12, Oriental Insurance Company Limited versus Ashok Kumar, 2021. Fact: the dispute was about the tardiness in the application being processed for compassionate grounds. Decision: the Supreme Court held that non-consideration of an application lead to an injustice that must be rectified. Ratio decidendi, timely processing of the application protects family from long-standing distress. Citation 2021 6 SCC 400. Case number 13, friends. State of Jammu and Kashmir versus Shahina Yas Rafiq, 2017. The case was evolved around misleading information about the criteria for compassionate appointment. Decision: the Supreme Court ensured the adherence to merit and factual basis when deciding on application. Ratio decidendi emphasize on eligibility verification aligned with family need criteria. Citation 2017 8 SCC 642. Case number 14, Dharampal versus State of Haryana, 2014. Facts: claim for compassionate appointments where the applicant faced delays owing to bureaucratic procedures. Decision: the court took a strict view, condemning unnecessary procedural delay in appointment cases. So there should be a unnecessary procedural delay and bureaucratic procedure should not happen there. Their application should be decided as early as possible after getting admitted that application by the concerned authority. Ratio decidendi, fair and expedient processing of applications must be upheld. Citation 2014 16 SCC 571. Then case number, today's case number last 15, Manor Singh versus State of Maharashtra, 2020. Facts: application was delayed and the court examined the implications on the deceased family. Decision: the Supreme Court emphasized fairness and transparency in processing such appointments. Ratio decidendi: compassionate appointments merit priority in consideration owing to their nature. Citation: 2020 T SCC 268. So friends, I will summarize with some statement. This judgment highlights the principle governing compassionate appointments in India, emphasizing humanitarian considerations interspersed with legal norms. They stress the need for timely, fair, and transparent processing of the applications, taking into account the financial position and emotional dimensions on the deceased family. Always refer to the largest legal text or judgment for throughout the understanding, or consult a legal professional for detailed evaluation. So friends, in short time, I want to cover maximum cases with short description, short judgment, short ratio decidendi, and citation. So we covered all this judgment. In next, after this Navratri, after Dasera, we will take our next Nani Palkiwala program to explain you more 15 cases on different subject, like maybe bail matter, or maybe custom act, or maybe another act. Okay. Thank you very much for listening me carefully. Just I am passing this to Manoj. Manoj, you can unmute yourself now and conclude.
Thank you. Yeah, thank you very much, sir. You have nicely explained that the main essence of this compensate is that you should apply timely within 1 year, because what we have seen in the maximum court cases that people are coming from after 5 years, 6 years, they are applying for the job. That is the main criteria of not getting their case admitted at the Supreme Court because of the delay. So one have to be very cautious in this, and they should apply immediately. If there is a minor, they should calculate. When the moment the person is becoming major, they should apply. That is the main thing that in the compensate we have learned. Thank you very much, sir. Thanks for putting a light on these points.
Thank you.
Participants. Thank you.
Thank you. Thank you very much. Thank you very much, Manoj, team Pooja, and all the participants. Thank you. Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।